The case given shows us how Tony, the plaintiff, is a professional ballet dancer who incurs an injury from an accident whilst he is rehearsing on stage. We are told the stage had undergone some repair works just a few days before. However, none of the stagehands swept the area. We will look at whether Tony has a valid claim against the Birmingham Ballet Company, referred to as the BBC, for their negligence. A duty of care was required, as in the case of Capara Industries Limited and Dickman. We need to establish whether the degree to which the loss or injury in this case was reasonably foreseeable. The BBC should have foreseen the injury that Tony would suffer if the stage had not been cleared or cleaned thoroughly after the repairs. The BBC is responsible for any damage that is caused by any party, whom in this case are the stagehands, as they are employed under the BBC. The omission made by the stagehands would result in the harm. Because Tony is a professional dancer, as stated by the facts we are given, he is employed under the BBC, providing and proving that a relationship does exist. The BBC is obligated to protect Tony, as every employer has a duty of care to ensure that they provide all their employees with a safe and conducive work environment. Thereby, it was the duty of the BBC to make sure that the stage was safe enough for Tony to use following the repairs. By this, it is reasonable to impose a duty on the BBC, as they ought to provide adequate safety measures, which include inspecting the stage after undergoing repairs. Thereafter, a breach of duty then needs to be established. Following the general rule, the defendant, whom in this case is the BBC, is expected to act with a reasonable level of skill in the activity they choose to undertake. Looking at the case of Nettleship and Watson, the given defendant is unable to rely or depend on their skill as a suitable defense. And so, because of this, had the stage been cleared and cleaned beforehand, it would have not caused the BBC much or costed them a lot, and Tony would not have suffered the injury. Thereby, because this was reasonably foreseeable, the BBC was in breach of their duty to Tony. Moving forward, the next element that needs to be present is causation. Using the but-for test given in the case of Barnett and Chelsea and Kensington, which is, but for the defendant's act, the prohibited consequence would have occurred. With this in mind, but for the stagehands cleaning the stage, Tony would not have suffered an eye injury. However, because the stage was not cleared, Tony did suffer an injury. It is important that we consider actus novus intervenens, which illustrates that it is more likely that the chain of causation is broken when a third party is involved. The third party in this case is Dr. Riff, who did not break the chain of causation. Yes, Dr. Riff had a duty to act as a reasonably prudent doctor would by not prescribing an experimental dosage that had the risk of making Tony's eye condition worse. However, because of the complex nature of medicine nowadays, it is possible that some doctors would have acted differently, depending on the medical situation. Had it not been for the stagehands failing to clear the stage, the stone would have not landed in Tony's eye, which caused the initial injury. Therefore, because of this, the BBC is liable for the full damage of Tony's injury because the damage was foreseeable. With this, Tony is able to make a claim in damages as he has fulfilled all the elements that are required. The next part that I will address is in regards to Maria. Maria claims that she has been diagnosed with a form of cancer that is contracted by coming into contact with asbestos fibers. She makes it known that she contracted the cancer by touching Bernardo, whom is her late husband's work attire, over a period of years as he was employed with the BBC. Following the elements that I mentioned before, the degree to which the loss or injury was foreseeable must be established if Maria intends on making a valid claim in negligence. The BBC owed a duty of care to Bernardo in order to avoid him coming into contact with any asbestos pipes. The BBC owed a duty of care to Bernardo in order to avoid him coming into contact with any asbestos in the pipes. As we are told, part of Bernardo's job role was to carry out plumbing duties, so it was foreseeable that there was a risk of him being in contact with the asbestos fiber regardless of the time frame. With this, a duty of care is owed to Bernardo. Once again, a relationship of close proximity needs to exist. Inasmuch as Maria was not employed with the BBC, she did possess a relationship with Bernardo, who came into contact with the asbestos. This is enough, as she also came into contact with the asbestos fibers by touching his work attire. Thereby, this can amount to sufficient proximity. The BBC can thus be held liable just in the case of McLaughlin and O'Brien. We know that the nature of the risk to get cancer is high once you have been exposed to carcinogenic and cancerous fibers such as asbestos. With this, the proximity of their relationship proves to be sufficient. Moving forward, a breach of duty needs to be fulfilled. Paying attention to the main rule of breach of duty, the BBC's conduct has fallen below the standard of care that is necessary in all situations. Therefore, we consider what a reasonable and prudent man would do. As in the previously stated case of Nettleship and Watson, it is made clear that the courts depend on 4 elements. To begin with, they assess the likelihood of the harm. From what we know, the BBC failed to make the necessary precautions. Therefore, even over a prolonged period, the chances of experiencing any harm still exist. Secondly, they consider how serious the harm is. In this case, Maria now has cancer, and this proves to be very serious as it is a terminal illness. Thus, the BBC breached their duty as an employer to provide a safe and conducive work environment. From that, had the BBC taken the necessary measures, this would essentially minimize all the possible risks. However, failure to make these precautions proved how careless they were. Finally, taking into consideration the criteria from Caparo, a duty of care is always required. However, the BBC showed no sense of urgency but rather chose to be ignorant. Using the but-for test again, we can safely assume that Maria had no other conditions prior to coming into contact with her late husband's work attire. With this, the chain of causation has not been broken, and so causation is thus established. With all this satisfied, Maria can therefore make a claim against the BBC. It is important to note that there may be contributory negligence from the London Ballet Company, where Bernardo also worked. Both the BBC and the London Ballet Company showed detectable amounts of asbestos on and around some of their piping, and so both these companies may be liable for contributory negligence under the Law Reform Act 1945. Maria is therefore able to make her claim.